Imagine the foundational document of your nation being debated in the country's highest court. Imagine two words, secular and socialist, words that have shaped India's identity for decades, suddenly being called into question. Should they remain in our constitution's preamble, or is it time to remove them? This is not just a debate about words, it's a debate about what kind of country we want to be. Recently, the Supreme Court of India was asked to examine whether the term secular and socialist should be removed from the preamble of the Indian Constitution. These words, inserted during the 42nd Amendment in 1976, have defined India's political and social framework for nearly half a century. But today they are at the center of a legal storm, with petitioners arguing that they no longer reflect India's original constitutional vision. And surprisingly, the court has agreed to consider this argument. Before diving deeper, let's rewind to 1976, a period when India was under a state of emergency. During this time, the 42nd Amendment was introduced by the then Prime Minister Indira Gandhi. This amendment added the words secular and socialist to the preamble, fundamentally altering the way India would be described. But why were these words added? India has always been a diverse nation, home to multiple religions, languages, and cultures. The word secular was meant to reaffirm India's commitment to religious neutrality. On the other hand, socialist was intended to emphasize the need for equality and economic justice, reflecting the state's responsibility to promote fair distribution of resources. But not everyone was in favor of these changes. Fast forward to today, the 42nd Amendment is being challenged by petitioners such as BJP leader Subramanian Swamy. Swamy and others argue that these terms were added without a proper parliamentary debate during a time when India's democracy was under duress. They also claim that these terms were not part of the founding fathers' vision when they drafted the constitution in 1949. The question they are posing is, can an amendment made during a national crisis still be considered valid today? And more importantly, should the preamble still reflect these ideals? In response to these petitions, the Supreme Court has made it clear secularism is not just a word in the preamble, it is a core feature of the Constitution. Justice Sanjeev Khanna, one of the judges hearing the case, highlighted how secularism is evident throughout the Constitution, especially in the fundamental rights under Part 3, which guarantee equality and fraternity. The bench also emphasized that secularism and socialism in Indian context need not be seen through a Western lens. These concepts, they argued, are unique to India and reflect a broader principle of equality and fairness. The Indian version of socialism, for example, doesn't mean complete state control of the economy, but rather it ensures that all citizens have a fair chance at success. However, the petitioners remain firm. Advocate Vishnu Shankar Jain, representing one of the petitioners, argued that these terms were not part of the original preamble and that their inclusion was never debated in the parliament. He pointed out that Dr. B.R. Ambedkar himself opposed the inclusion of the term socialist during the Constituent Assembly debate. Ambedkar believed that adding the word socialist would curtail liberty and interfere with the free economic system envisioned by the founding fathers. Jain reiterated that amendment was passed during a time of national crisis and therefore does not represent the will of the people. Another aspect of the debate centers around the meaning of secularism. The petitioners argue that secularism, as it is understood in India today, might not fully align with the original intent of the Constitution. They claim that the term could be interpreted as imposing a Western idea of state-religion separation, which may not fit India's unique context where religion and culture are deeply intertwined. However, the Supreme Court has repeatedly upheld secularism as a fundamental aspect of India's constitution. Justice Khanna reminded the petitioners that even without the word secular in the original preamble, the constitution's provisions clearly reflect India's commitment to religious equality and neutrality. So what happens next? The Supreme Court has agreed to further examine whether the preamble should reflect the date of the original draft from 1949 or be updated to account for the changes made in 1976. However, the court has not yet issued a formal notice to the central government, signaling that the case is still in its early stages. The next hearing is scheduled for November, and the decision could have significant implications for the future of India's constitution. The debate around the term secular and socialist is more than just a legal issue. It's a reflection of the larger questions facing India today. How do we define equality? What role should religion play in the state? And most importantly, what kind of country do we want to be moving forward? forward. As the Supreme Court continues to deliberate, we as citizens must also reflect on these questions. Should India's preamble change with the times, or should it remain as it was envisioned in 1949? Should the term secular and socialist remain in the preamble, or is it time for change? Let me know in the comments below. Don't forget to like, share and subscribe for more deep dives into the issues shaping our nation. And if you have any topics you would like me to explore, leave a suggestion in the comments.